Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with an update on the Tanur custodial death case. This case relates to the alleged harassment in jail of persons arrested in connection with alleged possession of narcotic drugs in Tanur, Mallapuram. The Kerala High Court was today considering a criminal writ petition filed by father of one of the accused persons who was arrested in this case. 5 persons were arrested by the police and allegedly taken to torture center in Tanur on 31st July. On the next day, one of the accused, that is Tamir Jifri, died in the police custody. The petitioner alleged that when he went to visit his son in the jail, his body was full of injuries from wounds caused by jail officials. During the hearing today, the court examined reports filed by doctors which showed various injuries on the body of the accused persons who were in the jail. The court, on an earlier occasion, had directed the Deputy Inspector of Prisons to obtain statements from doctors who treated the accused persons lodged in the jail and to conduct an inquiry into the allegations of torture. The court, on perusing the reports, felt that further independent investigation was necessary. Therefore, Justice P.V. Kunhikrishnan has today directed Chairman of Legal Services Authority Kozhikode to file a report after investigation into alleged harassment in the jail. The court has posted the matter after 3 weeks. Also, let me tell you, in September, the Kerala High Court had handed over the investigation into the custodial torture and death of Tamir Jifri to the CBI. The other accused persons had obtained bail and were released from jail after being in custody for more than 50 days. Stay tuned with us for further updates. In a significant update, the Delhi High Court has granted police protection to a couple who got married against the wishes of their parents. The court observed that where the parties are major, their right to marry a person of choice is protected under the Constitution of India, and even their family members cannot object to such a relationship. The couple got married in April this year against the wishes of their parents and have been cohabiting together happily. The couple moved court seeking protection and told Justice Tushar Rao Gadela that a coordinate bench in August this year had quashed an FIR registered by the woman against the man after she took a stand that she was forced by her own family members to file the case on false and frivolous grounds. The court has granted relief to the couple, observing that being a constitutional court, it is expected to further their constitutional rights. Accordingly, the court directed the Delhi police to provide protection to the couple and ensure that no harm befalls either of them, particularly from the woman's parents or the family members. The Madhya Pradesh High Court has refused to quash criminal proceedings lodged against Coca-Cola for an allegedly fungal infected Maaza mango drink displayed for sale by a retailer. In this case, the sampling of the drink was taken in March 2013 by the food safety officer on suspicion of adulteration. The report by food analyst opined the drink as unsafe for consumption due to fungus growth formation on neck and mouth of the bottle and also on product's surface, which was a clear violation of Food Safety and Standard Act. Therefore, the food safety officer filed a complaint against 8 accused persons, including the petitioners. Then in 2014, the magistrate directed issuance of summons against absconding accused persons, including the petitioners. This current petition was filed seeking quashing of this order. The court has observed that Coca-Cola was responsible for ensuring that none of the food products deemed as unsafe post-expiry period remain in the store of the retailers, even if the product is not directly sold to the end consumer by the company. The single judge bench of Justice Vivek Rusia also held that it was still unclear as to whether the manufactured drink reached the distributor and the retailer well before its printed expiry date, and that such an issue must be decided at the stage of trial after relying upon sufficient evidence. The Madras High Court has expressed its surprise at Katta Panchayat being conducted to socially boycott a man and penalize him for using excess water in his shop. The court was hearing the plea of a man named Muthupalam of Rajapallayam village seeking directions to the police to initiate appropriate action against certain villagers and prevent social boycott of him and his family. He informed the court that he had rented 3 shops and was paying a monthly rent to the society without any default. Further, he informed that since the shops were in a dilapidated condition, he sought permission from the society to use the borewell water. However, the executive committee of the society conducted a meeting and asked him to pay a fine of 15,000 rupees for using the borewell water without prior approval, and also asked him to extend an oral apology during the Panchayat. That when he refused to vacate the shops on direction by the president, secretary, and other members of the society, a group of people illegally closed all the shops and even threw all his belongings on the road, causing him heavy loss. Following this, he and his family members were excommunicated. On the other hand, the respondents submitted that Muthupalam was not paying rent for the shops and had used excess water than the 2 pots that was permitted for every shop's usage. Justice D. Nagarjun expressed his surprise, saying that even when the country was in an era of Chandrayaan, a person was being boycotted merely for using excess water. Further, the court directed district collector to constitute a committee consisting of the district revenue officer, additional superintendent of police, etc., to inquire into the allegations of excommunication. The Delhi High Court has dismissed a petition challenging appointment of senior IAS officer Nidhi Chibbar as chairman of Central Board of Secondary Education, that is CBSE, by way of a bureaucratic reshuffle. The petitioner, that is Independent School Federation of India, challenged her appointment and also sought her discontinuation from the post, and further prayed that the entire record may be produced pertaining to her eligibility and experience relating to the position. Chibbar submitted an affidavit to the effect that she had worked in the education department for 48 months in the cadre of director and above. Her counsel submitted that the allegations made in the petition were incorrect and that she had the qualification and experience in the field of education as per the criteria in the vacancy. Perusing Chibbar's affidavit, the court observed that prima facie it was not satisfied with the averments made in the plea and thus rejected it. Furthermore, Justice Chandradhari Singh added that the writ of quo warranto is issued in cases where there is a finding that the person holding the public office does not possess requisite qualification to be appointed to the position. That Chibbar was well qualified for the position and that the petition was nothing but a gross misuse of process of law. And lastly, the Kerala High Court has granted bail to a man who allegedly attacked a woman for rejecting his marriage proposal by using a chopper and explosives. The accused allegedly attacked the victim in April 2022 for rejecting his marriage proposal. He attacked with a chopper, explosives, and petrol, and even destroyed the window glasses and set fire to the kitchen by pouring petrol. He also allegedly attacked the victim's family, who came to rescue her. In the attack, the victim lost her 4 fingers. He was then charged for criminal trespass, causing grievous hurt, attempt to murder, and other provisions under the Arms Act and the Explosives Act. The counsel for the accused contended that he had been in custody since June 2022 and should be granted bail as he has already undergone a long period of detention. On the other hand, the senior public prosecutor opposed it, stating that previous bail applications of the accused were rejected because he was a serious threat to the victim and that he might abscond if bail was granted, as he had absconded earlier. The court took note of the fact that the victim had left Kerala and was residing at some other place due to fear of the accused. The single bench of Justice Beku Kurian Thomas stated that the accused had already undergone a long period of detention. Further detention would result in conviction without trial. The court allowed the bail application and imposed stringent bail conditions, including a warning not to intimidate or threaten the victim. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us. You can support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.